Our resolution calls for it. I've talked incessantly in private meetings with Chairman Hyde toward this end, and I hope that all of us will commit ourselves to that goal. If I have anything left of my minute, I just want you to know that, in my view, the American people have a deep sense of right and wrong, of fairness and privacy. And I believe that the Kenneth W. Starr investigation may have offended those sensibilities. Who are we in the Congress? And what is it that we stand for? I yield myself 15 seconds, Mr. Speaker. Do we want to have prosecutors with unlimited powers, accountable to no one, who will spend millions of dollars investigating a person's sex life? Is that the precedent we're setting? Who then haul them before grand juries? Every person that they've known, 15 more seconds, Mr. Speaker, of the opposite sex, the person that they had contact with, and then record and release videos to the public of the grand jury questioning the most private aspects of one's personal life. Please, I beg you not to denigrate this very important process in Article 2, Section 4. Thank you, Mr. Speaker. I would now yield to a senior member of the Judiciary Committee, the gentleman from Massachusetts, Mr. Barney Frank, for 2 minutes. 2 minutes, sir.
Gentleman from Massachusetts,
How much time is?
2.5.
I thank the gentleman. Someone inaccurately, well-intentioned, but inaccurately said the Democrats were agreeing there should be an inquiry. No, let me define what we say. We accept the fact that the statutorily designated independent counsel sent us a referral, and we are obligated to look at it. But what our resolution says is, let's first look at what he has alleged, and assuming that it is true, decide whether or not those things are impeachable. There's a very real question. If you look at the dismissal of the charge that Richard Nixon didn't pay his income tax because it was a personal matter, that would suggest some of these are not impeachable. You get to the question of lying. In fact, both the Speaker and I have been reprimanded by this House for lying before official proceedings. That has not kept either of us from continuing to do our duty to our best possible. We will have to look at whether or not these are impeachable issues. But the question is, do we look at those, or do we look at a whole range of other things? And I think my Republican colleagues fear that there is not enough in those accusations to meet the impeachment standard. And that's why they refuse and refuse and refuse to limit it, not to get into the, not just a fishing expedition, but the deep sea fishing expedition of Whitewater and the other matters. And scope affects time. It is because they are holding out the hope that something will turn up after 4 years about Whitewater and the FBI files and the travel office and all of these other accusations that have to date proven to be dry holes for those trying to get Bill Clinton. They want to not limit the time because they need to keep it open. But here's what that means in terms of time. Under our resolution, which calls for a December 31st deadline, we would begin work right away, on our time. This Congress is about to adjourn, and on our time, which would otherwise be not dealing with the public's business, we're ready to get into it. Under their resolution, let me make it very clear to you, they have no real plans to do anything during October. We've read about that. They're not going to start till after the election. They're not going to start till 2 months after we got Kenneth Starr's report because they think it won't play out well in the election. So vote for their resolution, and you will find that the American people's time will be taken up again next year. We're ready to do it now on our time and get it out of the way. They are asking you to give them a mandate to stretch it out, wait till after the election, and let it dominate next year's to our detriment, just as it has so far.
Gentleman from Illinois.
Mr. Speaker, I'm pleased to yield 2.5 minutes to the distinguished gentleman and a member of the committee from California, Mr. Rogan.
Gentleman from California is recognized.
Mr. Speaker, first, in entering this debate, I consider it a great personal privilege to be allowed to follow two men for whom I have such profound respect, gentleman from Michigan and the gentleman from Massachusetts. And I want to say as a Republican that as we begin this procedure, I start with the presumption that the President is deemed innocent of any allegation of wrongdoing unless and until the contrary is shown. And every reasonable inference that can be given to the President must be given to the President. It's unfortunate that some of today's rhetoric would suggest that this resolution seeks nothing more than to have carte blanche opportunity for Congress to inquire into the President's personal lifestyle. Nothing could be further from the truth. However, it is our purpose, it is our legal obligation to review any President's potentially constitutional misconduct within the framework of the Constitution and the rule of law. When serious and credible allegations have been raised against any president, the Constitution obliges us to determine whether such conduct violated that president's obligation to faithfully execute the law. We must make this determination, or else forever sacrifice our heritage that no person is above the law. This Congress must decide whether we as a nation will turn a blind eye to allegations respecting both the subversion of the courts and the search for truth. Mr. Speaker, I fear for my country when conduct such as perjury and obstruction of justice is no longer viewed with opprobrium, but instead is viewed as a sign of legal finesse or personal sophistication. This House has an obligation to embrace the words of one of our predecessors, Abraham Lincoln, who called on every American lover of liberty not to violate the rule of law, nor show toleration for those who do. Mr. Speaker, there's a difference between knowing the truth and doing the truth. We have an obligation to both, and we have that obligation despite whatever personal or political discomfort it might bring. For as Justice Holmes once said, if justice requires the truth to be known, the difficulty in knowing it is no excuse to try. Let our body be faithful to this search, and in doing so, we will be faithful both to our founders and to our heirs.
Gentleman from Michigan.
Mr. Speaker, to close debate on our side, I'm proud to present for the balance of our time the gentleman from Michigan, Mr. Dave Bonnier.
Gentleman from
The
Michigan is
whip.
recognized for 3 3/4 minutes.
Thank you, Mr. Speaker. We gather today to make a serious decision. What the President did is wrong, and he should be held accountable. Today, we have an obligation to proceed in a manner that is fair, that upholds our constitutional duties, and allows us to get this matter over with so we can get on with the business of the American people. Unfortunately, the Republican proposal meets none of these standards. It is unfair, it is unlimited, and it prolongs this process indefinitely. Under the Republican plan, Congress will spend the next 2 years mired in hearings, tangled in testimony, and grinding its gears in partisan stalemate. And today is just another example of that partisanship, that unbridled partisanship. There are 435 members that serve in this body, more on the floor today than I've seen in a long time, representing each about 500,000 people. And what has happened in this proceeding today? 2 hours of debate, 2 hours. Members having to go and beg for 20 seconds to talk to their constituency about one of the most important votes they will ever have to cast. Mr. Speaker, you just said it a few minutes ago, that this is one of the most important debates that we will have. Why are hundreds of members of this body being denied the opportunity to express themselves? This is a charade of justice. The American people, through this truncated debate, are being railroaded. Today's proceedings are a hit and run. The Republican leadership's long-term strategy is very, very clear. Drag this thing out week after week, month after month, and yes, year after year. Not for the good of the country, but for their own partisan advantage. The Democratic amendment guarantees that any inquiry will be fair, that it will be limited, and that we will complete our work by the end of the year. Mr. Speaker, the American people already have had all the sordid details they need, more than they ever wanted. Do we really want 2 more years of Monica Lewinsky? 2 more years of Linda Tripp? 2 more years of parents having to mute their TV set so they could watch the 6 o'clock news? We in this chamber have the power to stop this daily mudslide into the nation's living rooms. If the Republicans spend 2 years dragging this investigation out, when will they deal with education? If you spend 2 years dragging this investigation out, when will you deal with HMO reform? If you spend 2 years dragging this investigation out, when will you strengthen Social Security? I urge my colleagues, let us put a limit on this investigation. Let's end it this year. Let's get back to working for our children and our families and for our communities.
Gentleman from Illinois.
I yield to the gentleman from California for a unanimous consent request.
Gentleman from California.
Mr. Speaker, I ask unanimous consent to revise and extend my remarks in support of the resolution.
Without objection. Gentleman from Illinois is recognized. Gentleman from Illinois is recognized for 4 minutes.
Thank you, Mr. Speaker. I ask unanimous consent to revise and extend my remarks.
Without objection.
I'm very sorry that you feel you were shortchanged on the debate. As you know, under the rule and under the Rodino format, you were entitled to 1 hour. We doubled that. I didn't think that was fair, but we could have gone on and much of the same thing said over and over again, but it would be too much for me to expect appreciation for doubling the time, but the hostility let me suggest to you who think this is going to go on like Tennyson's brook, just on and on and on. The 22nd Amendment to the Constitution says the Congress shall assemble at least once in every year, and such meetings shall begin at noon on the 3rd day of January. We're out of business at the end of the year. Our money runs out. And if we're to continue, if there's anything to continue, we'd have to reconstitute ourselves. I don't want this to go 1 day longer than it has to. Believe me, this is very painful, and I want it ended. We're not going to go on and on and on. But Mr. Rodino faced up to the problem of time limits, and here's what he said. And why do you reject Mr. Rodino time and again in all of these issues? He's our model. He's the one we're following. And here's what he said. The chairman recognizes, as the committee does, that to be locked in to such a date would be totally irresponsible and unwise. The committee would be in no position to state at this time whether our inquiry would be completed, would be thorough, so that we can make a fair and responsible judgment. We're not flying by the seat of our pants. We're riding on Pete Rodino's shoulders. That's why we can see so far. As far as standards are concerned, something that you have repeatedly brought up, let me quote from the wonderful report by the Rodino Committee concerning the Nixon impeachment on the question of standards. Listen to Mr. Rodino. Similarly, the House does not engage in abstract, advisory, or hypothetical debates about the precise nature of conduct that calls for the exercise of its constitutional powers. Rather, it must await full development of the facts and understanding of the events to which those facts relate. That's what we want to do, develop the facts through an inquiry. On with Mr. Rodino. This memorandum offers no fixed standards for determining whether grounds for impeachment exist. The framers did not write a fixed standard. Instead, they adopted from English history a standard sufficiently general and flexible to meet future circumstances and events. Thus spake Peter Rodino, and that is our model for this adventure, this excursion, this journey that we're on. Now, look, this is not about sexual misconduct any more than Watergate was about a third-rate burglary. It was about the reaction of the chief executive to that event. Nixon covered it up and got in the direst of trouble. The problem with the President Clinton situation is a reaction which we believe, and we want to find out, and if we don't get the information, we'll reject it, caused him to lie under oath. Now, lying under oath is either important or it isn't. If some people can lie under oath and others can't, let's find out. If some subjects are liable, that is, you can lie about them, and others are not, let's fine-tune our jurisprudence that way. But if the same law applies to everybody equally, that's the American tradition. And that's what we're looking at. This has not anything to do with sex. It has a lot to do with suborning perjury, tampering with witnesses, obstructing justice, and perjury, all of which impact on our Constitution and on our system of justice and the kind of country we are. The President of the United States is the trustee of the nation's conscience. We are entitled to explore fairly, fully, and expeditiously the circumstances that have been alleged to compromise that position. We'll do it quickly, we'll do it fairly. We want to get this behind us and behind the country and move on. But it's our duty. It's an onerous, miserable, rotten duty, but we have to do it or we break faith with the people who sent us here. I yield back the balance of my time.
Time has expired. Does the gentleman move the previous question?
Thank you for the prompting, and I certainly do.
Without objection, the previous question is ordered. For what purpose does the gentleman from Virginia rise?
Mr. Speaker, I have a motion to recommit at the desk.
Is the gentleman opposed to the resolution?
I am, Mr. Speaker.
The gentleman qualifies. The clerk will report the motion.
Mr. Boucher moves to recommit House Resolution 581 to the Committee on Judiciary with instruction to report the same back to the House forthwith with the following amendment. Strike the first section and insert the following. That A1, the House of Representatives authorizes and instructs the Committee on Judiciary, in this resolution referred to as the committee, to take the following steps within the time indicated in order, fully and fairly, to conduct an inquiry and, if appropriate, to act upon the referral from the independent counsel, in this resolution referred to as the referral, in a manner which ensures the faithful discharge of the constitutional duty of the Congress and concludes the inquiry at the earliest possible time, and consistent with Chapter 40 of Title 28, United States Code, to consider any subsequent referral made by the independent counsel under Section 595C of such Title 28. 2, the committee shall thoroughly and comprehensively review the constitutional standard for impeachment and determine if the facts presented in the referral, if assumed to be true, could constitute grounds for the impeachment of the President. B, if the committee determines that the facts stated in the referral, if assumed to be true, could constitute grounds for impeachment, the committee shall investigate fully and completely whether sufficient grounds exist for the House of Representatives to exercise its constitutional power to impeach the President. C, if the committee finds that there are not sufficient grounds to impeach the President, it shall then be in order for the committee to consider recommending to the House of Representatives alternative sanctions. D, following the conclusion of its inquiry, the committee shall consider any recommendation it may commend to the House, including 1, one or more articles of impeachment, 2, alternative sanctions, or 3, no action. The committee shall make such a recommendation sufficiently in advance of December 31st, 1998, so that the House of Representatives may consider such recommendations as the committee may make by that date. E, if the committee is unable to complete its assignment within the time frame set out in subsection D, a report to the House of Representatives may be made by the committee requesting an extension of time.
Pursuant to the rules of the House, the gentleman from Virginia will be recognized for 5 minutes, and the gentleman from Wisconsin will be recognized in opposition for 5 minutes. The gentleman from Virginia.
Thank you, Mr. Speaker. I yield to myself 1 minute. Mr. Speaker, the motion to recommit that I'm pleased to offer this afternoon is well tailored to the challenge that we have before us. It offers a framework for a full and a fair review by the House Judiciary Committee and a full and a fair review by the House of Representatives. It assures that we give deference to the historical constitutional standard for impeachment, which has evolved to this House over 2 centuries. It assures ample time to consider carefully any of the facts that are contained in the referral sent to us by the Office of Independent Counsel, which rise to that constitutional standard. It assures that the entire matter will be resolved promptly and that the nation is not distracted by a prolonged inquiry. Some members, Mr. Speaker, would prefer that there be no review. Some would have us investigate for more than a year a wide range of matters. The resolution that we're offering through this motion to recommit steers a middle course, a careful review limited to the materials that are now before us. With the rules we offer, the House will discharge its constitutional obligations in a manner that is both thorough and expeditious. I urge the approval of this motion to recommit, and I'm pleased to yield 1 minute to the gentleman from Virginia, Mr. Scott.
The gentleman from Virginia is recognized.
Mr. Speaker, the motion to recommit will correct several of the most egregious problems with this resolution. If the amendment is not accepted, we will be voting for an inquiry that cannot end. So long as people send allegations to the committee will inquire and go on and on and on. The amendment establishes a reasoned approach by which we would consider the allegations before us and come to a conclusion. This amendment would add focus to the deliberations because some of the star allegations are not worth inquiring. In fact, the Republican counsel found some of the allegations so flimsy that he didn't even mention them during his presentation to our committee, and many constitutional scholars have already expressed the view that none of the allegations amount to impeachable offenses, and the question isn't even close. Finally, Mr. Speaker, make no mistake about it, a vote for this amendment is not necessarily a vote for an inquiry, because some who are for an inquiry and others who are against any inquiry all agree that if you're going to have an inquiry, it ought to be fair.
Gentleman from Virginia.
Mr. Speaker, I yield the balance of our time to the Democratic leader, the gentleman from Missouri, Mr. Gebhardt.
The gentleman from Missouri is recognized for 3 minutes. Without objection.
Mr. Speaker and members of the House, it's almost a month to the day that we stood here and debated whether or not to release the materials that Ken Starr had sent to the Congress. And I tried to say at that time that this was a time of utmost importance to us as a House of Representatives and to all of us as a people. I said then, and I repeat today, that we are engaged now in what I believe to be a sacred process. We are considering whether or not to ultimately, if we get that far, overturn an election voted on by millions of Americans to decide who should be the chief executive officer of this country. The last time we did this, Barbara Jordan, who I think really became the conscience of the period, said this. She said, "Common sense would be revolted if we engaged upon this process for petty reasons. Congress has a lot to do. Pettiness cannot be allowed to stand in the face of such overwhelming problems." She said, "So today we are not being petty. We are trying to be big because the task before us is big." I said the other day that this is a time to be bigger than we really are. We're all human. We all make mistakes. We all give in to pettiness and pride. We all give in to doing things wrong for the wrong reasons. But this is a time when our Constitution and our people ask each of us to reach inside of ourselves, to be bigger and better than we really are. In my view, we shouldn't have two resolutions, or a resolution and an amendment out here today. I believe if we had succeeded in what we should be doing, we would have one resolution agreed to by all 435 members today. The question, you see, is not whether to have an inquiry. The question today is what kind of inquiry will this be? Our amendment is simple, and I think it's common sense. First, it says it must be focused. We operate under a statute that we passed from the independent counsel that said there could be referrals from the independent counsel on possible issues of impeachment, and we should take that up. And that's what's before us. Our resolution says stick with those referrals. And we listened to the complaints of the other side, and we said, well, maybe there will be more referrals. So we've amended the language, and we say if there are more referrals, we will deal with them as we should under the statute. Second, it must be fair. Last time we had Watergate, the committee spent a good deal of time considering the standards and the history of impeachment so that all the members of the committee and on the floor would understand the historic process that we're involved in. None of us do this very often. We don't think about this very often. So it's vital and important that we all know what it is we're doing and whether or not the facts that are out there rise as a prima facie case. That has not been done in this case. Third time, we say let's get it over by December the 31st, before the new Congress comes into session. Why do we say that? We say that because we believe deeply that for the good of the country and the good of our people, this must be done by the end of this year, before there's a new Congress. And why do we say that? We say it because we live in a dangerous world. The world economy is in a shambles. Our own economy is threatened. Issues like education and health care and economics need to be on the front burner of this Congress. That's what we must be working on. If we stay here for 3, 6, 9, 12 months, 2 years in suspended animation while we go over every charge that's out there, we will hurt our country and our people and our children. Now, Mr. Hyde has said, and I believe, Mr. Hyde, that we should do this by the end of the year. But he also said New Year's promises sometimes get broken. Mr. Hyde has said that we should not be on a fishing expedition. But others in the party, I've heard, even leaders in the party, the Republican Party, have said, well, we've got to look at Travelgate, and we've got to look at Filegate, and we've got to look at campaign finance, and we've got to look at the Chinese rocket sales. And you say it again. I've really thought a lot about this. I've really thought a lot about it. I've tried to think to myself, what is our problem? And I think I've identified it. Our problem is we don't trust one another. You say that if you use our language that we're not going to do what we say we're going to do, that we're going to drag it out, that we're going to try to frustrate the purpose of having this inquiry. And all I say is, we have put our words and our actions to follow that belief. We have said if there are other referrals, we will take them up. We have said that if we get to the end of the year and we need more time, that you can come to the floor and more time will be granted. You run the House. But when we see your resolution, we don't see trust, because the words that we're looking for, that we're going to try to get this over by the end of the year, that we're going to try to stick with these referrals and not go into everything under the sun and drag it out for 2 years and it'd be a 2-year political fishing expedition, those words are not there. Finally, let me say this. We're all profoundly hurt by what the President has done. He has deeply disappointed the American people, and he's let us all down. But this investigation must be ended fairly and quickly. It has hurt our nation, and it's hurt our children. We must not compound the hurt. I've asked their conscience and to vote for what in their heart and their mind and their conscience they think is right. And I come to the floor today to ask every Republican member to do the same. This should not be a party vote today. This should be the attempt of every one of us, humble human beings, who come to this majestic place where we settle our differences peacefully and not with violence, to say that I am voting for what in my heart and my mind is the best for the country and the best for the American people. Thank you.
Gentleman from Wisconsin.
Speaker, I rise in opposition to the motion to recommit and yield 1 minute to the gentleman from Florida, Mr. Kennedy.
Gentleman from Florida is recognized.
Thank you, Mr. Speaker. I thank the gentleman for yielding. As we consider the motion to recommit, I would ask that the members of the House on both sides of the aisle step back and consider the fact that what is proposed in the motion to recommit is without any precedent. There is no case in the 200-year history of the impeachment process in this country in which a process similar to the process which is proposed here has been followed. None at all. And I believe that's something that we should take very seriously. I believe we also have to be aware that if we adopt the motion to recommit, we are setting a precedent today, and I believe it would be a terrible precedent, a precedent that would be fraught with the potential for harm stretching far into the future of our country. Now, consider the process that this motion sets up. First, we are required to assume the truth of allegations which the President and his lawyers vigorously deny. I don't think that's the right thing to do. We should find out what the truth is. But while we're following this process, we put aside the weighing and the balancing of the facts and the judging of the credibility of witnesses. Having put aside our duty to weigh the facts and find the truth. We are then called on to make a solemn determination concerning whether impeachable offenses were committed if the assumed facts, which are denied by the President, are at some later point determined to be true. This simply does not make sense. It will only cause delay. It has never been done before, and it shouldn't be done now. I would ask the members of the House to reject this contrived, ill-conceived procedure in the motion to recommit. We need to follow the precedent established in 1974, the precedent that the gentleman from Missouri has asked us to follow. We should support the resolution recommended by the Judiciary Committee.
Gentleman from Wisconsin.
Mr. Speaker, I yield myself the balance of the time. Mr. Speaker, the question before us in this motion to recommit is whether we should make ourselves slaves to the clock or attempt to find out the truth. And let there be no mistake about it. Nobody's conduct is under investigation here but that of the President of the United States. And if he did not commit the allegations that have been sent forth to us by the independent counsel, we would not be faced with discharging our awesome constitutional responsibilities. This should not be a race against the clock. And don't take my word for it. Take the word of a respected senior Democratic member on the other side of the aisle, the gentleman from Indiana, Mr. Lee Hamilton, who said yesterday, quote, "I've had a lot of experience with investigations. Time limits create large incentives for delay," unquote. Do not give anybody an incentive to delay and string this out by establishing an arbitrary time limit. Now, my friends on the other side of the aisle have said that this will be a never-ending investigation, and they haven't read the 20th Amendment to the Constitution of the United States. The 105th Congress goes out of business on January 3rd, 1999. This resolution expires with the 105th Congress and would have to be renewed by a vote of the House on the opening day of the 106th Congress. So all of the arguments over here have been about just 3 days. And I think that the gentleman from Illinois, Mr. Hyde, in following the Rodino precedent and just almost adopting the Rodino resolution word for word, has done the right thing. Now, on February 6, 1974, was the last time this House of Representatives had to do the sacred duty of commencing an impeachment inquiry. The resolution upon which Mr. Hyde's pattern was introduced by Chairman Peter Rodino of New Jersey. There was bipartisanship on the Republican side of the aisle in commencing an impeachment inquiry along exactly the same lines against the Republican president. That vote was 404 to 4. I would ask my Democratic friends to be as bipartisan today as the Republicans were back in 1974 by rejecting this motion to recommit and joining with us to discharge our constitutional duty and move the previous question.
About the last 40 minutes of the debate in the House before a series of votes took place, first on the Democratic alternative, a motion to recommit, and then on the Republican resolution. The outcome of the vote turned out to be 258 members for and 176 against. You can see it on your screen, the party breakout. We'll take a look at those 31 Democrats who voted for the impeachment inquiry and the next couple of graphics that we'll be able to show you. And we'll start to get your phone calls. We've got the phone numbers on the bottom of the screen. The number for Liberal callers, if you're a Liberal, 202-624-1111. For conservatives, 202-624-1115. And for moderate viewers, 202-737-6734. We've got about 10-15 minutes for your comments here, and we'll try to get those list of the Democratic members who voted for the impeachment inquiry. It's about 31 Democrats, and we'll show those to you. We'll start to take your phone calls now, starting in